Now, there's an enforcement process because there's a code, but it wouldn't be valuable to us unless there was a method to enforce the code. So the enforcement process includes ethics cases, which are cases involving misconduct or violations of the code, and then arbitration would have to deal with money, and then mediation, again, where the parties would agree to mediate, and that's a relatively new discovery for us.
And what we're finding, we find it in the law as well as here, that in many cases, once you can get the disputing parties together and you have somebody who can play an intermediary role as a facilitator, that person might be able to facilitate a settlement through mediation.
As opposed to arbitration.
As opposed to arbitration, which is a little more formal process, not as formal as a lawsuit, but still a little more formal. Mediation is kind of a facilitated settlement. Now, once the parties agree in mediation as to how they're to resolve an issue, they actually sign a contract, and that contract then becomes enforceable. Now, if voluntary mediation did not work out, then the parties would go
elevate to the next level,
which is the arbitration level. And by the way, effective January 1st of 2002, National Association has decided and declared that local boards and associations need to provide mediator services for their members.
So how does the process work? A complaint can be filed either by a realtor or by a member of the public. Now, NAR has a note to this filing of a complaint. In filing a charge of an alleged violation of the Code of Ethics by a realtor, the charge must read as an alleged violation of one or more of the articles of the code. The standards of practice may be cited in support of the charge. And we've said that several times, but we want to reiterate that it is the violation of the article that we're most interested in, substantiated by standards of practice.
And also the case interpretations can be cited as well, but they would not be violations.
So there's a process here within the organizational structure of an association of realtors, and we begin with the Grievance Committee typically. The Grievance Committee does not hold a hearing. It's kind of like a grand jury, and it will go out and collect evidence and decide whether or not there is enough evidence to warrant an ethics hearing or an arbitration.
Yeah, typically they will look at what's presented and say, well, even assuming that all of this is true, is it enough to state a violation? If it's not, they will dismiss it right there. If it does state enough that there could possibly be a violation, then they would move to the next level, if it's an ethics complaint, towards an ethics hearing, decided by another group other than the ethics Grievance Committee people.
So the Grievance Committee, the Grievance Committee looks at a lot more cases than the hearing panels do.
They're trying to decide things like, was it filed within 180 days, which is the rule? Is it an arbitrable matter? Money. And is it realtor to realtor, or is there a non-member, so then it has to be voluntary rather than mandatory? That's the job in the initial screening.
So it starts with the complaint being filed, and then it goes to the Grievance Committee.
Now, the Grievance Committee, interestingly enough, might even get involved so much as to assist in modifying or changing the complaint so that it is compliant with the rules.
That's interesting. They actually look at it and say, can they do this? You filed under the wrong article?
Yes.
You should have filed under this article? And they can change that. Wow, that's some power. Well, the ethics hearing then, there can be some penalties for this, and what are the types of penalties that someone could anticipate for a violation, code violation?
Well, on the softer side, you'd have, letters of warning and reprimand. They could require attendance at certain courses, like an ethics course. There could be fines up to $2,500. Suspension.
From the association?
From the association. Very important to note that they cannot do anything that would affect suspension of your real estate license.
Not a licensing body.
Absolutely. They could, however, for egregious conduct, they could refer to the licensing agency and say, that's just such gross misconduct that maybe they would want to take some action. And here's something new, publication.
I'll say it's new. I remember we used to say, you have a violation. You say, let's publish this so everybody reads about it, because when the Department of Real Estate sends you a bulletin, typically the first place realtors go is to see who's had their license suspended or revoked. So if we want to be effective with the Code of Ethics, maybe we just publish all the results, and that has always been a no-no from the National Association of Realtors.
Well, you're always fearful of claims for defamation and libel. You know, the findings of fact of these ethics hearings are not revealed. So this would only be the fact that a particular person was disciplined, maybe the general nature of the discipline.